Please on the court. Good morning, everyone. Welcome to the Supreme Court. Today we're hearing one matter, Viking versus TMP. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Because of the COVID pandemic, we are using what we're calling the Fauci rule, which is you may lower your mask when you are speaking. We will only use that, however, if there are no objections from anybody in the courtroom. Does anybody have a problem with us using the Fauci rule? Because if you do, we'll do this with mask up. Let the record reflect there are no objections. Counsel, are you ready to proceed? Oh, hang on. Step to the podium. I believe Justice Ecker has something to say, some housekeeping before we start.
Yes, thank you very much, Chief. So in preparing for the appeal today, I just had an occasion to go to the trial court docket, online docket, and I noted that when I was a trial judge in Bridgeport in 2017 and early 2018, there's an individual calendaring thing and arrangement, and this case was one of the hundreds on my individual calendar docket. I did see that I had some preliminary involvement. I think I ruled on a scheduling order. I ruled on a motion for request to amend the complaint, and maybe one or two other things, nothing dispositive, and I confirmed in my own mind that there was nothing there that in any way, shape, or form, directly or indirectly, bears upon any of the substantive issues in the case. And so I'm obviously very comfortable sitting and plan to do so, but I wanted to raise that. I assume counsel, in not raising the issue before, has no problem, but I just wanted to confirm that explicitly on the record, that neither side has any issue with me participating in the appeal.
Prior to coming here today, the clerk's office had notified us of that situation, and nobody did object to it, Your Honor.
Oh, great, great. Thank you very much.
Thank you. Counsel, if you identify yourself for the record and let me know whether you wish to reserve any rebuttal time.
Attorney James Mulholland, I'm appearing here this morning on behalf of the Appellant defendant, TMP Construction Group, LLC. The members of that LLC are in attendance for the argument this morning.
Thank you, counsel. That's a unidirectional microphone, so if you could move it towards your mouth, we'll hear you better. No, up. Move it towards you. Yes. Thank you.
Better?
Better.
If I may please the court.
How much time do you wish to reserve?
I'd like to reserve 5 minutes for rebuttal, Your Honor.
Whenever you're ready.
All set. Your Honors, this is a pretty straightforward contract dispute that involves a general contractor and a subcontractor. The matter traces its roots back to December 2016, where my client, who is a drywall contractor, entered into a subcontract with the plaintiff, which is a general contractor, regarding the construction of a fairly substantial housing project in the city of Bridgeport. The contract was for $1.5 million. My client, as indicated, was a drywall contractor with other miscellaneous scope of work related thereto. The parties began working on their contract, but soon after they started, they ran into some problems, and eventually, without getting into the details because they're not really relevant here, in May of 2017, the relationship was reached the point where they could no longer work together. At that point in time, and I believe it was, to be precise, on May 19th of that year, the general contractor gave notice to my client, the subcontractors, that they were exercising certain rights that are spelled out in the party's contract. And the party's contract, which is an exhibit, I think it's Exhibit 1 to the plaintiffs at the trial, and it's also in the record, is a very substantial contract. It covers everything from A to Z. But the one provision that they were relying upon at that time was the provision 11.1, which in our view is where this case rises and falls. 11.1 is in the provision of this detailed contract that relates to it's called, I think it's a termination section of the contract. It's where you have this particular provision, 11.1, which is not a termination though, 11.2, which is termination for cause, and I think there's a termination for convenience that follows that, which is standard in these types of contracts. They relied upon 11.1 when they gave notice to my client, and that's an exhibit is also in the record. And 11.1, if you read it, and we've stressed it from day one of this case all the way up until today, 11.1 is very specific, and it indicates quite clearly that if you rely on 11.1, the general contractor, you are entitled to get, what it basically says is, come back to do the job. If you don't do the job, what we want you to do in 3 days or 2 days, whatever the time period is not really that important here, then we're going to bring in our own people and we're going to do your work. And we're going to finish the work. We're going to work on it. We're even going to make repairs that we feel are necessary because of your work.
Counsel?
Yes.
I have a question. On A59 of, A57 of your appendix is the trial court's decision. How do you, what is your argument that the trial court got wrong, if that is your argument, that there are other provisions in the contract that the jury had, including section 9.1, which allows for the recovery of additional damages beyond the value or the amount of the contract to fix or repair work that the subcontractor did inadequately?
Yes.
How does that, doesn't that support the jury's verdict of the additional amount for repairs?
I don't believe so, Your Honor.
Why not?
Okay. First off, if we talk, we're zeroing right on 9.1 because that's really the heart of this case is 9.1 versus 11.1 and 11.2. You have to look at those three provisions of the contract and try to decide what the intent of the parties was, and it's pretty clear what it was. 9.1 was not in the pleadings. It was not in the evidence. It wasn't in the trial. It only surfaced when Judge Stewart raised it on her own, sua sponte, in response to my motion to dismiss after the trial was, when I tried to get the verdict set aside.
Well, isn't that part of the problem? We don't have any transcripts to know what was said during closing argument or during the trial. And I thought the court said that this was argued, as Viking pointed out in its closing argument on the memorandum. Was that an argument made to the jury by Viking?
As a 9.1?
Yes.
No, I don't believe there's any reference to that.
Were there any questions asked about 9.1?
No, it never only came up when Judge Stewart raised it in her decision. That was the first time it appeared.
But we'll have to take your word for it because we don't have trial transcripts to go back and read?
I don't think that's really, I don't think you need the transcripts to come to it's illegal, it's a question of law. She has, and her memoranda is quite clear in my mind, which is.
The question of whether there were questions asked of witnesses or arguments made in closing argument about a different provision of the contract is not a question of law. That's just what happened at the trial. How can we determine what happened at the trial if we don't have trial transcripts?
I don't think, Your Honor, that it's a question of fact. Again, I still think it's a question of law. And
I understand your argument is that you're raising a question of law. My question, however, is purely a question of fact. What happened during the trial? How can we determine that without transcripts?
I'm representing, Your Honor, that it never came up. It doesn't appear in any of the filings that are in the record. It's not in any of the requests to charge. You have the request to charge are part of the record. There's no reference to 9.1. You have counsel's briefs that I put in here in response to my earlier motion to dismiss, nothing relating to 9.1. You have the record is, I think, pretty complete that there was never a 9.1 raised in this case at any time. And the complaint, there's nothing in the complaint, even though in the complaint, the plaintiff takes great pains to list out provisions of the contract they think are relevant, and none of that 9.1 doesn't appear.
The jury had the entire contract?
They did, yes.
And so they could read through it?
they could read the contract, and that's what Judge Stewart determined, that the jury could read the contract, and then what she determined was that the amount of the damages that were awarded, $45 some odd thousand, was to the penny what the damage claimed at trial was for the plaintiff for their cost of repair. To be fair, the defendant did not present any objection or evidence or contest the damages in this trial at all. Our defense was what we're arguing today, that the contract doesn't allow them to go over the balance of the bill under 11.1 that they didn't terminate. And the judge, in raising 9.1, there are 4 reasons why that shouldn't apply here. One is that it wasn't pled, and we have a requirement that there have to be some notice to the other side of which are cases. They didn't plead any breach of warranty case. 2, if you read the contract, and it's tedious, but if you read the contract from stem to stern, you'll not find one definition of what the warranty period is. 9.1 only applies during the, quote, warranty period. We don't know what that is. It's not in the record. It's not in the contract. It's not spelled out. 3, there was no evidence, and you won't find it in the record where my client was given any written notice under 9.1 that they had an obligation to come in and fix the repairs, which they could have done at their own cost. And 4, the last overriding objection I have, or my client has, is that if you come in through 9.1 through the back door, you make 11.1 a nullity, and our law is crystal clear that you shouldn't interpret one provision to nullify another provision.
Counsel, I hear your argument. I guess we'll wait to hear from the other side to hear what they say about whether anyone mentioned 9.1 or the concept embedded in that provision, during trial. And I also hear you say the transcripts don't help because you're talking about the absence of an argument as opposed to the presence of something.
Correct.
Nonetheless, there is this separate head of damages here that seems to have been presented as under a category called repair damages as opposed to cost of completion. Repair sounds like to fix something, presumably because it wasn't right. The complaint, which I did go back and look at, talks about when there's a list in paragraph 10 of the first count of the suffered financial harm and detriment. A is the cost to complete. B is Viking was required to obtain other contractors' labors and material and equipment to correct the work improperly performed or to perform the work itself. So that sounds like, it could be a breach of warranty. It doesn't necessarily, I guess, have to be a defect. Warranty is defects in workmanship or materials, right?
Correct.
So what do you say, though, to the idea that the repair seems to implicate provision 9 and the work improperly performed appears to implicate provision 9?
Well, I have 2 responses to that. The first one is, again, back to 11.1. 11.1 it specifically and expressly includes within it repairs, and it says...
Yeah, but the contract says it's cumulative. Let's just say you're wrong about that. Okay. These are cumulative remedies, and it just seems to me to be a weak argument to say, look, you're stuck under 11.1 if it's a repair, and you can't recover under Section 9. So I interrupted you, but I assume we don't buy that. What's your other arguments?
Well, there are the 4 that I listed to start off with, that aside from the fact that, and you're talking about it, you believe that maybe there's enough in the pleading to suffice to make out a case of breach of warranty. I understand what Your Honor is saying in that regard. I think that a breach of warranty action really requires more specific pleading to put us on notice of what their claim is. But aside from that, there's nothing in the contract give the jury or a judge or anybody any understanding of what the warranty period is. I think that even as a practical matter, it generally is a period that follows after the contract is accepted, and then there's a warranty period after you move on, and the general contractor, the owner can say, hey, wait a minute, this drywall, it's defective, and you got.
Was there testimony about the 45? We don't have a copy of Exhibit 115 because neither side provided it to us, which the trial court said was the exhibit showing the $45,000. But was there testimony about what those repair costs were for?
They're not in the exhibits presented. I thought all the exhibits were part of the record.
Well, let's put that aside. Was there testimony at trial about defective workmanship and materials? What was the $45,000 about? How was that separated out? What did that consist of?
My recollection back to the trial was that the plaintiff did not put on any witnesses as to their damages per se, so they did not have people testify as to the work they did or didn't do or what they did. They pretty much provided Exhibit 115, which was an itemization of their damages. I believe they had one of their principals testify, and they put in some records of support. I think it was McKenzie Painting or some other company, but their damage claim was entirely based upon their summary and exhibits that went with it, and we didn't challenge them at the trial. There are exhibits that maybe Brother Counsel could identify specifically for you that do itemize the $45,000, but like I said, our position was that there was no entitlement to it. We weren't aware of 9.1 was being raised at that point. And jumping back to the 4 reasons again, I claim they don't plead it properly. There's no understanding of what the warranty period is, what that means, and there was no evidence in the record to support the notion that my client has received any notice. 9.1 has a condition preceding to it that you have to give my client notice, which makes sense because he has to be able to go in and cure his defect at his cost. Otherwise he has to bear the cost of whatever somebody else might do to it. So I think it's mentioned at least twice in 9.1, you have to give my client notice. And I do believe that the way to reconcile 9.1 with 11.1 is to treat 11.1 as operative up until the time the work is accepted, and that 9.1 only comes into play after the contract and work has been accepted, and it's like when you build a new house, there's a 1-year warranty period. You buy the house, you close, you move in, you got a year to bring a warranty claim against the builder. I think that's what I'm confident that's what 9.1 means, and that's the only way you can actually, I think, reconcile it with 11.1. And remember that.
Let me ask you this question, if you don't mind. What are you looking for? You looking for, as I read your conclusion in your brief, you're looking for a defendant's verdict?
Yes.
I mean, that we know the jury did not want. We have, and we can have this conversation off of, I'm looking at the jury interrogatories. They certainly didn't accept your jury interrogatory on breach of contract. So entering a judgment for the defendant, I mean, I'll hear what you have to say about that, but that's certainly not what they wanted to do.
Well, I suppose in that regard, then I would ask, maybe the appropriate remedy is a remand with instructions to the trial judge to enter a judgment for $1.
A judgment, a what?
Enter a judgment for $1 nominal damages.
They didn't want to do that either. I mean, they found against you on the breach of contract. I suppose, I mean, you maybe there'd be a new trial, maybe, because if we can't figure out if they conform themselves to the law or the instructions. I take it your opponent wanted more money, significantly more money. And so, I invite you to think about whether that's what you want, but I mean, what we're struggling with is why the jury, having found against you and for the plaintiff on the breach of contract, would have come up with this dollar amount, right?
No, I understand. But if you look at the jury forms, I mean, you can see the jury form. I think the jury was in and out 3 times, 4 times. They first wrote 0.
But that's what we have. That's what we have. I mean, it's a general verdict as it relates at least to that.
You can see, though, they wrote zero a couple
Yep,
times.
no,
and they
I
put the
mean,
number
these are
in.
lay people, you know, and
I think they were confused as to how they were going to assess damages here.
but at least we have a finding without any real transcript to measure this against or other things other than your representations and your briefs, that we know they wanted to enter a verdict for the plaintiff. And
not
what to
challenging that.
do about your argument about the $45,000 only matches up to something that wasn't argued or pled is kind of vexing, because maybe they have discretion to enter damages to a certain extent, right?
I-
They didn't have to accept the plaintiff's number.
No.
Which
and
could have
they
been higher.
didn't. They clearly didn't, and what they were seeking was cost to complete damages, and much of the trial and the closing arguments related to, whether they could get cost to complete damages over the balanced bill, and clearly they said no. And we're not disputing that they found a breach of contract. It was a hotly contested case. There was a counterclaim. There was also another case that was tried alongside of the companion case against my clients individually that stemmed from this whole transaction. I think Judge Ecker was involved in that one as well. And they rendered a verdict for my clients. They rendered a verdict for my clients on the count 2 of the complaint. They struggled with count 1. They mightily struggled because they didn't really quite know where to go with the complaint and with the contract.
Is there any question as to whether, I take it you think that they knew what they were doing on those judgments, because they had
course.
to, right. But is there any question that if we sent it back, whether those have to be in play too?
I would think not. I would think that the other side has not taken any appeal of any of those findings. There was also a claim made by my clients regarding tools and equipment, and they ruled against my client on that. But it was a multifaceted case. As you can see, there was 119 exhibits, all from the plaintiff. I don't think he put on any exhibits. But our defense was what I'm indicating here today. Your question is, we're not disputing that the jury found a breach of contract. I'm not here arguing that they shouldn't have done that. But you can have a breach of contract but not have any damages that flow from it, and that's one of the essential elements of a breach of contract action is damages. And our claim from when this case was first filed till right what I'm talking to you today is there's nothing in the contract, and there's nothing in the contract which
But
which
counsel,
allows-
part of your claim is, and you're asking for a defense verdict based on an instructional error. And as I look
Yes.
at your opponent's appendix on A14, which contains your request to charge, your request 11 focuses or asks the court to instruct the jury on provisions of section 11.1, 11.2 of the contract.
Yes.
So I have your request to charge, we have your request to charge, we have your opponent's request to charge, and then we don't have the court's instructions. So they're not exhibits here, and we don't have a transcript of what the court actually instructed the jury, do we?
I thought
Can-
that the charge was part of the record on appeal. It's in the trial record.
So is the request to charge, so neither side attaches or provides transcripts of the court's actual charge. So do we know whether the court chose your instruction or your opponent's? And we don't have a transcript of the closing arguments to know whether either side relied on just focusing their argument on 11.1 of the contract or other provisions of the contract that called for damages.
Well, I think at A62, which is page 14 of if I have it in front of me correctly, the judge's, maybe that's,
I'm sorry, I can't hear you. You're pointing to something in the record, counsel, if you could.
I'm looking at the judge's decision that you're referencing,
Yeah.
Judge Stewart's decision.
No, I wasn't referencing the judge's decision. What I'm suggesting is I have your request to charge, your opponent's request to charge are attached as appendices, your objection to their request to charge, but we don't know what the court actually instructed.
Well,
We don't have the court's instructions, do we? Do you know where they are?
Well, she sets it out in her memorandum of decision.
Yeah, well, that's what the court is focused on. I understand that's the court's reasoning, But we don't look at just one sentence of the court's instructions. We look at the entire instructions. We don't have that in our record, do we?
Well, I suppose it depends how you define record, because she lays out exactly what her charges verbatim to the jury on damages. And she didn't give the instruction I asked for. That's crystal clear. And essentially, the instruction she gave in many ways mirrors the one asked for by the plaintiffs. But I determined that since she had spelled it out in her memorandum of decision, that would be sufficient for appellate purposes, that she gives us verbatim and she block quotes it as to what she actually charged on damages. I asked, as you know, that she charged what I'm arguing here today, that, you know, the jury couldn't go in, they could find a breach of contract, but they couldn't go anything above the balance to bill. And because the balance to bill was in the control of the plaintiffs at all time, we were done. So, I mean, that's really the case is, to my mind, as simple as understanding. I did ask for that charge, and she mentions that in her decision, and she says what I asked for a charge, and she indicates that I took exception to her decision not to give the charge, which I thought was her way of assisting in any appeal. And so the issue, we just kind of touched all the issues that I have. I think she should have given the request for a charge that I requested under the terms of the contract. And the contract, if you look at 9.1, 11.1, and what I stressed in my brief is that the plaintiffs, you know, they're here. We didn't have to be here. They could have just terminated the contract under 11.2. All they had to do was send out a proper notice under 11.2, and they could have gotten all of their damages. And at the trial, I submit, because we didn't oppose the damages, they would have got all their damages. They would have got the $300,000, $400,000. But they chose not to do that, and they had some reasons for doing that. Maybe
So,
they can
but what's puzzling here?
I'm sorry?
What's puzzling here, counsel, at least to me, and it sounds like it may be puzzling to other members of the court as well, I think it's the point that Justice Doria raised. So the jury got it, at least in part. It looks like the jury got it. And the reason I think we can say that with some confidence is the jury didn't award Viking $339,706 that it requested as cost to compete.
Correct.
It presumably, I mean, it could have, we don't know. Maybe it's because they didn't think those were proven. But maybe it's because they thought that there wasn't a right to collect those damages under the contract in accordance with exactly your theory. But what's weird or odd is that the jury did find it justifiable under the contract as charged to award this $45,000, right? That's what we're trying to figure out. On what basis did that happen?
Exactly. That's the point that's the point of my appeal. There is no basis to support it in the contract, none. I think that they went back and the zero, a no, a yes, a zero. The judge kept sending them back saying, you have to come up with a number. You found a breach of contract, as was commented earlier. We need some damages here. And, you know,
Does the theory have to be argued? I mean, and this is not a rhetorical question.
Sure.
I understand your point. Hey, they never even, I mean, if it's true, if it's accurate, they never mentioned Article 9. Nobody drew the jury's attention to it. Nobody argued it. This is a lay jury, but they figured something out that the lawyers didn't figure out. That's a reasonable question. Is there anything to prevent that from happening legally? I mean, why couldn't they say, look, we think under Article 9, you know, gotcha, hey, we should have gone to law school, you know, kind of thing. Is there anything legally to prevent that from happening?
well, I think the standard for reviewing that would be could a reasonable juror, in the place of these jurors, with this contract in place of them, could a reasonable juror read 9.1 in the context of the entire contract as allowing them to give those damages? That would be the test, I think. Is it reasonable for a reasonable juror to read that 9.1 to allow them to do what they did? But I'm sorry, my time is up.
Thank you, counsel.
May it please the court, Luke Conrad, Hinckley Allen. With me is Timothy Corey, trial counsel for Viking Construction, Inc., or counsel for the appellant.
Thank you, counsel.
One key distinction that my brother failed to raise during his entirety of his argument is that the trial court determined that 9.1 is not the only vehicle to a potential jury verdict. And that is a substantial failing in the appeal. The court specifically pointed out a number of other provisions. Specifically at page 11, the court's decision stated there is ample evidence upon that the jury might reasonably have reached their conclusion, and therefore the court will not set aside the jury verdict. It did not state that 9.1 was the only vehicle to find for
Well, what else do you have, counsel? I mean, the trial court said that Article 4 is not in play, right? So 11.7 is what else are you relying on other than Article 9?
So, Judge, that's a good question. And so under Article 5.8, which the trial court also referenced at page 8 of the decision, it states approval and payment of the subcontractor's monthly requisition does not constitute or imply acceptance by the contractor or owner of any portion of the subcontractor's work. And the implication or the ramifications of that provision is that as the contract payments come in, that sets the quote-unquote balanced bill that TMP argues under 11.1 operates as a cap. So after payment, if we, Viking, the appellee, discover that there is defective work, we can, and certainly there's evidence in the record, for example, Exhibit 66, that TMP is overbilled, we can adjust that balance to bill. And so therefore, as the trial court pointed out, 5.8 also can operate in conjunction with 11.1 to increase or decrease the balance to bill. And so it's perfectly reasonable that the jury could have found, after evidence of TMP's overbilling, that there was additional funds left in the balance to bill above and beyond the $350,000.
Is that ever argued? I mean, so one issue that's underlying this is what did you argue and what didn't you argue? Because although I suppose the jury could figure it out on its own, there is this concept of fairness to the parties to know what they're fighting against. Was 5.8, was that ever argued? And is counsel correct in saying that 9.1 was never argued?
5.8 was identified during the course of the trial. As Your Honor mentioned during questioning of my brother, there was significant testimony during the trial about a number of different components of the breach of contract claim. And the significant monetary value that we were seeking was certainly much greater than $45,000, and the significant portion of our claim was the cost to complete. That said,
let me just be specific. Was the jury ever told, you can adjust the balance to bill under 11.1 because of the way that 5.8 operates? Was that ever argued?
We did not argue that specific point.
Was Article 9 ever argued? Breach of warranty. My clients are entitled to collect under Article 9. Look at this, ladies and gentlemen, the jury. Let me read it to you, or whatever. Was that ever argued?
I think the answer is no. We did not specifically stand up and say Article 9.1 provides X, Article 5.8 provides Y. And the important distinction is that our complaint does not go through and set forth every single provision of a 137-page subcontract. What we did is we put on evidence, factual evidence of a number of different breaches, and as in our closing argument, we referenced a few key provisions. And certainly the lion's share of the damages that we presented had to do with the cost to complete. The $45,000 and the cost to repair, there was evidence, Craig Bienek testified during the trial, of the comeback work that subcontractors were required to do. There is evidence, I believe, in our appendix of the notice emails that went from Viking to TMP, including the photographs of the defective work. And there is also a PowerPoint that the jury saw that addressed the defective work. So to say that they were not aware of the issue of defective work is just simply because the number isn't there, I don't think is a fair
I guess what I'm
representation.
struggling with, counsel, is just that the jury was also told about your $330-some-odd thousand it cost to complete. They rejected that, right? So the jury had something in mind about why it was rejecting those damages, presumably because of the limitation language in 11.1. I don't know, maybe you have a different theory. But still allowing the $45,000. And I'm just trying to figure out, like, what was in the, what could have legitimately been in the jury's mind to permit that distinction to be made?
I would say, in addition, Your Honor, in addition to the 5.8 issue, which we discussed, the 9.1 issue, there's other provisions in the contract. And although while the trial court rejected provision 4.7, because it states that it arises out of delay, there is, if you look at the language, if you look at the specific language of 4.7, the contractual provision, which is Exhibit 1, it states the subcontractor agrees that should any delay caused by acts or omissions of the subcontractor otherwise damage contractor and or contractor's other subcontractors, contractor shall have the right to set off any and all sums due to subcontractor the amount of such damages.
But counsel, I'm looking at A56 of your opponent's appendix, which is page 8 of the trial court's post-trial motion rulings. And the court says they agree with TMP that section 4.7 would not support the jury's verdict. But then the court goes on in the last paragraph of page 8, if you have that in front of you. The court finds, however, that other provisions of the contract support the jury's award. As Viking pointed out in its closing argument and in its opposition to the memorandum to this motion, 5.8 provides. So the court is suggesting that your client argued in closing argument other provisions of the contract, including 5.8, which the court finds would support the jury's award. So my question to you is, did your client, I know you were not trial counsel, but did trial counsel argue to the jury other provisions of the contract supporting the award of the extra damages to repair work that was allegedly performed poorly? Is the trial court correct?
Counsel?
He's just picking up something.
I can.
Just a moment.
Counsel? Counsel? Mr. Mulholland? You were distracting Justice Kahn.
Sorry, Your Honor?
You were distracting Justice Kahn by getting up.
I'm sorry, Your Honor.
Thank you. I apologize. It was distracting to me that your opponent got up and went to the podium for the record, but it also obviously was distracting to you. So my question is, did the trial court correctly point out, because nobody submitted transcripts, so we don't have transcripts, we don't have the court's final instructions, we don't have the closing argument to see what was argued, but is the trial court correct that in closing argument, your client argued other provisions of the contract, including section 5.8?
Yes. During the course of the trial, Viking asserted a number of contractual provisions, and in closing argument, a number of contractual provisions that we walked the jury through, including 5.8. And to that end, section 5.8 has to do with the approval of the monthly payment requisitions. And the monthly payment requisitions really constitute the individual line items for every component of the project. And the components of the project broken down are is each piece of the work performed in a manner that TMP can be paid. And in this instance, a portion of that work was the drywall work for which they had TMP had already been paid, including $45,000 for work that we then had to pay separate subcontractors to do that same work.
Again, we don't have the transcripts of the closing arguments. Did TMP object to that line of argument during closing argument to say this is outside the scope of the evidence or what was introduced, or we didn't have notice this claim would be raised? Any such objection filed?
As Attorney Mulholland referenced, there's very, very little objection to any of the evidence in the case. It was solely the legal argument with respect to the contract.
I don't want to, I've asked you enough questions, and I don't want to, if my colleagues have any questions, I certainly don't want to preempt them. I do have a question on 5.8. Where does that get you? I mean, you say it changes the bill to balance amounts under 11.1, but my understanding, correct me if I'm wrong, the whole reason I'm hung up on 11.1, and I suppose the other side, 11.1 limits the recovery. It doesn't allow your client to get new money, damages. It limits the recovery to a set-off, it sounds like, right? So whatever the balance to bill is, higher or lower, I mean, I guess I still don't understand. The question still remains, what gives the jury the power under this contract to award an additional payment of $45,000? And I don't get how 5.8 helps you there. I'm sure it's something I'm missing, and maybe everyone else in the courtroom understands it, but could you give me 30 seconds on that?
So 5.8 gets to the heart of what is the amount of the work performed on the project and what is the proper value for what the work is performed on the project. And there was testimony during the course of the trial from Michael Appellant that at certain portions of the latter part of the project, when the disputes arose, that TMP was, for instance, billed at 90% of their work and had performed about 60 or 65% of the work. And so what the implication was and what we argued during the course of the trial, certainly because there were counterclaims involved from TMP, and I know that's not here on appeal, but it gets to the heart of your question, which is that the amount that TMP bills, and therefore the amount that's remaining in the contract and available to be taken, is not set in stone. It can move up and down depending on what the actual amount is of the work that is performed, not a piece of paper that is submitted by TMP that says we're 90% billed. They may be 60% billed, and then I may have 30% left in the contract on a $1.5 million contract. I may have funds remaining. So there was significant testimony during the course of the trial from Mr. Appellant going back and forth about the remaining balance to bill and what was left in the contract, what TMP had been paid for, what they were not paid for. And so that's really the relevance of 5.8, because it sets the value of the argument, which we don't accept on 11.1, about the cap on the balance to bill.
Let's say we agree with your opponent, and let's say we agree with him along the lines of the contract, the 11.1, which seems to match up to what the award of damages was not pled, was not argued. Let's just assume that. He suggested that perhaps in his discussion with me that, I mean, in the first instance, he'd like a directed verdict for the defendant, maybe alternatively a nominal damage award. What do you think would happen if we agreed with them, with your opponent?
It's not entirely clear for what the appellant's asking for, but I think that the law would, in the state, would be that if the court were to set aside the jury verdict, which we don't think they should, that it would be remanded for a new trial because it's a determination by a jury.
And I mean, in a lot of ways, that wouldn't seem too fair, because you didn't get all you wanted, and the jury didn't, so you would have another shot at that, right? I mean, that might be right, but
Certainly, we would contend that if the determination of the jury on the amount of, the sole remaining count on the remand, would argue, would be the Vikings breach of contract count.
And do you think it would have to be retried on the whole breach of contract count? Or, I mean, your answer might be, this isn't intended to be a friendly question. You might want the judgment for you on the breach of contract, and it would just be a damages hearing. Do we know? I mean, it seems, do we have discretion to determine what that would be? Or is there contract law on what, if we thought, this sort of sounds like, to credit your opponent's argument, like an inconsistent verdict. A plaintiff's judgment on a contract claim, but not one you pleaded, and the damages don't seem to make sense.
I'll answer your question. I think my first comment would be that the breach of contract provision contains a number of factual allegations, and it doesn't necessarily pigeonhole the individual provisions against which we can and cannot recover. But to answer your question, I think based upon the court, the standard of review looking at a jury award, and based upon the record that is in front of this court, and that the appellant has made based upon his argument to set aside the verdict, I think that the breach of contract count would have to be remanded to the trial court to be tried in its entirety on that count. I don't think you can solely do it just based on the damages, because there isn't, the appellant hasn't made a record by which the court could take that action or could support that remand on that basis of damages alone.
Okay, thank you.
In addition to 11.1 and 11.2, the provisions that were raised by the court and raised by my opponent, it is important to note that Section 11.7 contains a provision that broadens the breadth of recovery under Section 11, which states any sum or sums chargeable to the contractor under any provision to the subcontractor may, at the election of the contractor, be deducted from any payments otherwise due or to become due to the subcontractor under this or any project or subcontract between the contractor. And then skipping further ahead, with any remaining amounts due to the contractor be paid by subcontractor, or contractor may sue subcontractor and its surety to recover damages. And our contention is this provision, when read in conjunction with 11.1, have two distinct purposes. 11.1 has the purpose of allowing the contractor, when the subcontractor is in breach, to utilize the project funds to repair or to supplement labor without being themselves accused of being in breach for taking project funds to allow the project to progress. And separately, 11.7, which allows other remedies under the subcontract, and allows the contractor to sue the subcontractor and its surety. In this case, there was no surety, the project wasn't bonded, but in any event to recover damages. And then in addition, we raised the issue of Article 12.7, which states that the remedies of the contractor and the subcontractor under the subcontractor shall be cumulative and shall be in addition to any other rights or remedies of the contractor. A few other notes from the court's decision. On page 7 of the court's decision, the court states, the court holds that TMP is incorrect and that the only route Viking could have taken to recover damages above the balance to bill is to terminate under 11.2. And then later on page 8, the court states other provisions of the contract support the jury's award. and it quotes 5.8 and states, 5.8 provides that the approval and payment of the subcontractor's monthly requisition does not constitute or imply acceptance of the work. Based on the evidence, a reasonable jury could find that Viking paid TMP soon after it submitted its requisitions without doing an inspection of the work before making those payments. The jury also heard from Craig Bienick that he found defects in the work and took photographs of those defects and hired someone else to make the repairs after TMP left. The argument with respect to the warranty claim, while the provision on 9.1 is under the section called warranty, it is not a separate legal warranty provision such as a UCC warranty. It is more a contractual construction warranty that provides that the subcontractor must repair any defective work during the course of the project, and that is a contractual obligation that certainly falls within the ambit of the first count, which is, quote, breach of contract. As pointed out, I believe, but during the questioning, I mean, our operative complaint, which is a second amended complaint at docket 126 under 10B, does state that Viking was required to obtain other subcontractors' labors and material to correct the work improperly performed by TMP. That's exactly what we contend is contained in the damages line item for the $45,000 that the jury awarded, and that lines up with the language in section 9.1, which states the subcontractor agrees to properly repair and make good without cost to the owner or contractor any and all defects due to faulty workmanship and or materials. And the language with 9.1 lines up with the language in our complaint under paragraph 10B of count 1. Ultimately, with respect to the breach of contract issue, the trial court made the determination based upon the review of the record that there was adequate evidence to affirm the award of the jury, and we would ask that the court do so on that first issue of that first claim of error raised by the defendant, TMP. As to the second claim of error, the issue of the jury instruction, the jury instruction itself presented by TMP under instruction number 11 was properly rejected by the trial court. And instruction number 11 contained essentially hotly contested factual items and was not necessarily a guidepost of the law that is required under the standard for jury instructions. It had ultimate conclusions with respect to Article 11.1 and concluded with the following statement. This is at appendix page 14. And I therefore instruct you to render a verdict in favor of TMP on Viking's breach of contract claim. Based upon Connecticut law, that's not a proper jury instruction. And further, the appellant has not raised any evidence or put forth any argument as to how they're prejudiced by the failure or by the failure of the court to accept accept the jury instruction that the court issued, which is contained in, I believe, in footnote 2 of the court's decision. Footnote 2 of the court's decision is a standard breach of contract provision, which is substantially modeled after the standard jury instructions. And there's no indication from the appellant that it's a legally incorrect standard or that otherwise deviates from the traditional jury instruction for a breach of contract claim. For this reason, Viking would ask that the appellant's second claim of error with respect to the jury instruction be denied. The third issue raised by the appellant on appeal is the issue of practical relief or subject matter jurisdiction. At the close of evidence, the defendant moved for a judgment of dismissal, contending that the trial court did not have subject matter jurisdiction over the breach of contract claim because there's no practical relief that could be afforded to the plaintiff. As set out by the trial court in their decision, both both the plaintiff in asserting the breach of contract claim and the defendant in answering the claim and asserting a counterclaim all relied upon the contract. The fact that there was a binding contract was admitted by the defendant in their pleadings, and the jury instruction that went in to the jury stated so that both the plaintiff and the defendant agreed that there was a binding contract. So, based on that and based upon the fact that the plaintiff had the ability under the contract to require some amount of damages, whether it be or some sort of relief, whether it be $0 or the maximum of its recovery, gives an adequate remedy, and certainly.
Counsel, can I interrupt for one moment?
Sure.
I'm wondering if we're just looking at this all wrong, maybe including me, and the arguments that have been made and so forth. I mean, we seem to be searching the contracts for a basis for an award of the specific contractual basis permitting the award of the damages. Contractual damages under Connecticut common law, as I understand it, are, what the jury was charged, right? The jury was charged and was asked in the interrogatory, one amount has Viking proven by preponderance of the evidence to be fair and reasonable to put Viking in the position it would have been in had they not breached. Your typical expectancy damages. And the jury found this is the amount. They would have still had to pay the cost of completion to somebody else. We're not going to give them that, maybe they thought. But we are going to give this extra $45,000 cost to complete. So why does anybody need a specific, unless there's a contractual limitation that says you can't get any damages except for as provided herein? Why do we need a contractual basis for the recovery when it's a common law contract claim? It's not meant to be a hostile question, but go ahead.
I think certainly during the course of the trial and the charging conference, Viking certainly argued that we were also entitled to common law damages as well. I think there is some appellate authority recently from the appellate court stating that if there are specific contract provisions that dictate the amount of damages in recovery, that then the party who has the benefit of that contract cannot use the common law to circumvent those same contractual provisions. But in this case, we would contend that where the damages are not specifically barred, we'd have the opportunity to use common law to.
Well, there is that provision in Article 12 that says these are meant to be cumulative, and I'm not going to look to quote it, but basically the contractor can rely on the law and claim any damages it wants under the law. Words to that effect.
Yes, and Viking also during the course of the argument during the charge conference and during the course of several motions, we have raised the issue of common law damages, and certainly we would contend that there's nothing contained in the contract, and certainly Article 12.7 would indicate that we would reserve all of our remedies, both under the contract and at law, where there isn't a specific demarcation of an item that has to be under that specific contract, which defective work would be, even if one was to accept TMP's argument with respect to cover costs or cost to complete, there still would be a separate potential recovery for defective work, which would be expectation damages, or the amount of money that we, Viking, paid out to other subcontractors to complete the work for which TMP had been retained to perform.
It just seems like that would be an easier argument. I'm surprised. Maybe it's been made. I don't know.
I believe that in our brief, we also had argued that, and in addition, part of the heart of our argument on this appeal is that contracts are to be read in their entirety, and the entirety of the contract includes 12.7, which certainly reserves our right, and Section 11.7 reserves our right on different remedies, both under the subcontract and separately. And so certainly to the extent that the jury found expectation damages, and to the extent that the trial court, the jury didn't find that Section 11.1 or Section 9.1 is a specific bar to recovery of damages, I think that Viking would be entitled to recover on that path. Following up on the issue of subject matter jurisdiction, certainly there's no basis or no.
You may finish that thought.
Certainly there's no basis on both based on the evidence adduced at trial and based on the arguments made in the record to support an argument that the court lacks subject matter jurisdiction. For that matter, Viking asked that the court deny the appellant's 3 claims of error and affirm the award of the jury.
Thank you, counsel. You have 5 minutes, counsel.
First off, I apologize for getting up. It was rude of me, and I shouldn't have done that. I apologize.
Thank you very much for that, counsel.
I'd like to go backwards. I'll keep it really brief, and I'd like to touch on some of the points that Justice Ecker raised at the end. First off, as to paragraph 12.7 of the contract, which is sort of the general catch-all provision in these contracts. And as Brother Counsel was noting, the law in that area is pretty clear that you can't use that provision, that catch-all provision, to undermine or to circumvent some clear contractual remedy that's in the contract, particularly in the commercial contract. And I cite those cases in my brief, and the most recent one on that was the Scandia case. I think I cited it as a late citation because it was decided by the appellate court after the briefs were filed. But you can't resort to common law remedies when the parties have clearly written out in their contracts what their rights and liabilities are in the contract. In this particular case, they spelled it out in great detail. And again, back to 11.1.
Well, getting to that point, counsel,
Yes.
let's assume you're correct and common law remedy is not available, and it's purely the contractual language.
Yes.
Your argument, as I understand it, is you're relying on Article 11 of the contract, which calls for what the damages ought to be when there's termination, correct?
Yes, they should have used 11.2.
Your opponents and the trial court seem to, in its opinion, says, hey, the jury could have looked at other sections of the contract, other provisions of the contract that allowed for additional recoveries. And you say, no, it's only Section 11 of the contract that governs, and 9.1 doesn't because it contradicts 11. But when I read 9.1, at the very end, it says, anything in this section or any other section of this agreement to the contrary notwithstanding. So it allows for additional recovery, and it specifically says, even if there's another part of this contract that contradicts this. So how is that not enough? How did the trial court get it wrong?
I think that the only way you can interpret 9.1 relative to 11.1 is that 9.1 only comes into play, and it wouldn't conflict with 11.1 in this situation, after the contract work is completed. It's a warranty period, and that provision specifically says it only pertains during a, quote, warranty period, which is not defined. So there's nothing in the contract. For some reason, it's not in the contract. We don't know what that is, nor would the jury know what that is. So all I can say is that I don't think that they clash with each other. I think they're readily reconciled, in which they should be in contract law. The two provisions should be read so that they reconcile with each other, not that they clash. And the way to do that is, since 11.1 says it does cover repair damages and it does stop at the balance to bill, then the only way to reconcile 9.1 with that is it comes at a different time period. That 11.1 doesn't apply after the contract has been accepted.
Counsel,
that would be my position.
you said several times that There is no explanation of what the warranty period is, correct?
Correct, there's nothing in there.
In that situation, if you put that before a fact finder, wouldn't the fact finder just use the reasonable and common meaning of that word?
I don't know if they could under the law. That'd be to me, that's a legal interpretation. Interpreting the language of a contract is a judicial function. Could a reasonable jury looking at 9.1 make a determination that the warranty period was what? I mean, I don't know what they would determine it would be reasonably. What would their guideposts be?
Their common understanding of a warranty period, just like the court would use unless there was some guidance saying that what that meaning really is.
I would suggest that it's not a reasonable interpretation by a juror. They wouldn't have enough information to make that determination. And in fact, again, 9.1 wasn't even on their radar when they went into deliberate. And to jump back, I know my time's short, back to 12.7, I know we don't have the record, and I don't want to get myself into that again, but 12.7 was not argued at all to the jury. It never came up, the catch-all provision, and 9.1 never came up. 5.8, I know there's been a lot of discussions.
But the jury was charged that it could award damages to put the plaintiff back into a position, you know, as if the contract had not been breached. That's a classic, right? I mean, you agree with that?
I do. That's a classic common law definition for damages in a breach of contract, but the parties defined what their remedies and liabilities were specifically and expressly. And if I just have one last second, I know my time's up. I just want to make the point is it's not an abstract thought here. There's an important function here that my client or anybody in their position, they get a notice under 11.1. They look at 11.1 and they say, well, we're only going to be liable up to the balance to bill. They make a determination at that point in time, well, we don't think we should finish the project. We're willing to let go of the rest of the contract. So getting an 11.1 puts my client in a choice position. Finish it or forget about the rest of the contract. Same thing for the plaintiffs. They made a decision to use 11.1, so they must have used it with the thought that they could finish it within the balance to bill. If they didn't, they should have went to 11.2. Shame on them. Thank you.
Thank you, counsel.
Thank you.